Hello and welcome to another episode of Taking Back Saturday, a Happy Buyers Club podcast where we break down the real estate market each and every Friday to help home buyers build confidence, follow a process, and hopefully buy really happy. I'm back in the hot seat today and we are joined by at least Chase and I's favourite property lawyer. These guys do all the work for our clients and they are not only extremely professional, highly communicative, try saying that 3 times fast, but they're really good people to boot. So no pressure today on our guest. And I'm not just saying that because we're going to have some lunch after this, but Natalie Pearson from JHK Legal in her first ever podcast.
Yes.
Welcome to the show.
Thank you. Thanks for having me.
Nat and I have just had a briefing on using our podcast voices. Mm-hmm. So we'll see how we go.
Do my best.
We'll be fine. I promise you. We are going to start this show being very boring though, Nat, if that's okay with you. We're going to get this question out of the way and then we're going to talk about far more exciting things in the world of property law and conveyancing. Searches. I reckon we would get a DM every week from a buyer being like, I've been sent this list of searches. What do they mean? What do I need? I don't know where to start. So, Nat, where do you start? What do you need?
All right. So we do send a searches list to buyers because in Queensland presently it's buyer beware.
Yeah.
So what that means is a seller will make lots of warranties in a contract. They'll make lots of promises about the property and basically it's up to the buyer to do their investigations and due diligence and searches to find out whether that warranty or that promise made by the seller is true or false.
Okay.
So essentially we send a searches list. It'll have a whole heap of searches like council searches, building approval searches, for example, Department of Transport main roads to check whether the property, if there's any plans to resume part of the property for widening purposes, flooding searches. We can do searches about whether there's any easements over the property, etc. So basically our job is to go through that searches list with the client in detail. And it's really having regard to what they're buying, as to what's going to be important for us to search for that client. So it is very specific to the client and the property.
So there isn't one size fits all, just get these and you'll be right.
No. I mean, there's a few that we always recommend. So if you're near a main road, always recommend Department of Transport main roads. For some people, they want to know whether the building is council approved or not. For others, they already know that it's not legal height and that's been disclosed to them. They're not too worried about the risk that goes with that. We'll always sort of do the free searches for clients like court searches to make sure the seller isn't involved in any litigation. The seller's not bankrupt. That's very important. We want to make sure the seller can sell the property.
Yep.
So there are a few of the mandatory ones that we would do or recommend.
Cool. How then does the searches that say you would perform on behalf of a purchase, how's that going to change when the new seller disclosure regime comes in? And maybe for all of our listeners who are like, what are you talking about? Give us the rundown, your 2 cents on what that is and then how it might change.
Yes. So everything's changing come the 1st of August.
It's 3 years in the making, but everyone's now panicking now.
That's it. It's okay. We look after other jurisdictions, not just Queensland. So in New South Wales and Victoria, they've been doing this for a very long time. So essentially, a seller will be required to provide a disclosure statement, and that disclosure statement will contain a lot of the searches that we would ordinarily do for a buyer now. It's not going to contain everything. So there's still some due diligence we need to do for a buyer. But a lot of those major problems or risks or concerns with the property will be disclosed up front before a buyer is required to sign a contract.
So things like building approvals, contaminated land, all that sort of stuff.
Exactly.
And is that something that a seller is going to engage a solicitor to do? Is there a real estate agent that's going to do that?
Definitely. I would say it's really important that the seller is disclosing the correct information. I would say they would engage a solicitor to do the correct searches, disclose what they need to disclose. Otherwise, there's a risk of a buyer terminating if that disclosure is defective. So it's really important a seller gets it right.
So a buyer has the right to terminate should they find something in their own searches, which they'll do anyway, that doesn't match up with what was disclosed?
If that statement's defective and that buyer's materially prejudiced, they would have a termination right. So.
Okay, there were some pretty big law words in there.
Yeah.
Let's talk about, so it sounds like from the first of August, and in my opinion, this is a good thing, that a solicitor, hopefully a good one, is going to be involved in the process of selling, maybe not buying earlier than they are now, when often there's so many buyers, and we've been the same, we've signed contracts on behalf of our buyers with your details on them, and the seller's like, I'll get a lawyer once it's unconditional.
Yeah, that's right.
So it's good that someone's going to be involved. In your opinion, subtle plug for JHK here, how early should a buyer be talking to a solicitor?
So as soon as you start looking, or you know you're going to buy, come and talk to us. We can recommend some special conditions or give you some advice about how to structure your offer, about, you know, sort of what we think a seller might or might not agree to, you know, in the current market. And just give you a bit of advice about also structuring and your buying entity and things like that as well.
Okay, cool. And do you guys do contract reviews and things like that? Or do you recommend them, given that so many of the contracts in Queensland are the same?
Definitely still recommend a contract review. I think we'll find that when the seller disclosure regime comes into effect, that lawyers will be engaged to also prepare contracts for sellers rather than agents. So there's probably less room for error in contracts, you know, from the 1st of August. But regardless, we would still recommend a buyer engage a solicitor, do a quick contract review. Sometimes the seller will, you know, say, I'll do some works or whatever the case is. It's important that if anything's been promised to you, that's documented in the contract, but in the correct way, so that there's recourse for a buyer if a seller breaks that promise.
Cool. I like that. I wanted to have a conversation with you around, you mentioned there you'll have a chat through with your clients about how they might structure an offer. The market is, I don't think it's as runaway as it has been for the last few years, but it's still fairly competitive, certainly at different price points. Buyers will often waive a finance clause or waive a cooling off period or something like that to make their offer look better than others. There are probably 3 really common clauses on a contract. Again, we're just talking about Queensland real estate here, but it would be a cooling off period, a finance clause, and a building and pest. Do you want to just give us a breakdown of what waiving each of those actually means?
So with your cooling off, a cooling off period in Queensland allows you to terminate within 5 business days from when the buyer receives the fully executed contract. If you do terminate during that cooling off period, you do pay a penalty. So it's 0.25% of the purchase price. So it's not great for a buyer wanting to terminate under cooling off because they have that penalty. So the other one's finance. With your finance clause, it gives you the ability to terminate if you don't get finance approval, provided that you've made a reasonable effort, you've put in an application. If you're declined, you can terminate, get out of the contract. With building and pest, you can obtain a report. If you're not satisfied with that building and pest report, then you can terminate the contract. And it's up to the buyer to be satisfied with that report. So if there's anything in that report that you're not happy with,
Scratch a paint.
or acting reasonably,
Yep.
because the seller could probably argue otherwise.
Yep.
If you are terminating under building and pest, the seller can request a copy of the report. So you would need to be able to point to something in there that a reasonable person would not be willing to purchase the property for that reason.
Okay.
So I don't know if there's a leak, you know, a water leak, for example, but you need to act. I wouldn't say scratch a paint. I'd say you'd be able to argue you're not acting reasonably in that regard. But So if a buyer wants to waive any of those conditions, they'll waive their rights to be able to get out of the contract, you know, for that reason.
Let's say somebody has a finance clause and they obtain their finance, but they turn around and they go, you know what, actually I've seen something better. It's come on the market today. It's Thursday. My finance is due tomorrow. They've got approval. Can they still terminate?
No.
And that I think is a really common misconception for so many people out there, that they think all these clauses are just in effect more cooling off periods where you don't have to then pay that 0.25% penalty. What happens if they try and pull out and they've got their letter and they try and say, oh no, I didn't get it?
So if the seller thinks that they can sell the property again for a better price and it's a really competitive market, maybe they will just accept the termination and maybe you'll be able to get out of it. But if it's a tight market, the seller might say, well, give me a decline letter, prove it. And if you can't, then you're in a sticky position. So
it's a serious clause.
it is.
Yeah, cool. And I think just to come back to that point on cooling off, where if you've got other conditions or you're not prepared to quite offer unconditionally, we're big fans of just waiving cooling off because certainly when we're making offers, and I would encourage everybody listening to this to make your mind up if you like that property before you make an offer. That penalty on cooling off exists to stop people putting 5 offers on properties on Saturday and just hoping for the best and messing with everybody else, the other 4 in the meantime for the next few days. It is a good looking condition to waive on an offer, but agents will understand probably why you're doing it as well. Okay, you answered my question about building a pest, which was good. I want to give you a worst case scenario for a lot of people. So we're big fans of putting subject to settlement clauses on properties if our clients have sold and are unconditional, but just as a protection in case their buyer was to get hit by a bus. The 0.1% chance that their buyer wouldn't be able to settle and the funds for their property are tied to their purchase. We like having our subject to settlement on there. What happens if you've got an unconditional contract and something does change in your life and you can't settle?
Yeah. So it's a difficult position to be in because once you've satisfied finance, you've waived your building and pest, there's no cooling off, and you've got an unconditional contract. In Queensland, you have to complete that contract. So you would only be able to get out of it if the seller agrees. So you might have to offer some kind of compensation to the seller if you really need to get out of it. But the real risk is the seller can say, no, you need to settle. If you don't settle, then you risk losing your deposit that you've put down. And that could be 10% of the purchase price. So
Are there any other penalties other than losing your deposit?
So the seller can sue you for specific performance or damages. So let's say, for example, you can't settle, you're in default, they take your deposit. If they try and resell the property but they can't sell it for the same price, they could claim the difference in the resale value. So they could also claim commission, marketing expenses, legal costs. So you could be up for a lot of money if you default.
And I think that's the really important thing to remember for a lot of people. Like, deposits are refundable up until the point that your contract is unconditional. And from there, and again, if you've ever bought a property, hopefully you've got a very scary looking email from your lawyer at the point of waiving that last condition, as you guys send, right?
That's it, yep.
There's nothing more terrifying than reading that email because it's like, hey, how good, you've bought a property, you love it, it's your dream home, but this is really serious and you've got to be able to actually perform and settle on this date.
Correct.
What happens if for some reason someone wants to settle but can't on the settlement date?
So let's say there's a delay with the bank, for example. Sometimes it happens. In Queensland at the moment, there's a clause 6.2. It allows a buyer to extend for up to 5 business days and a seller to extend for up to 5 business days. So there's a little bit of wiggle room as long as you haven't waived that condition when you've signed the contract, which some people do.
Yeah, they try to do it at Christmas time. A lot of agents will try and do it at Christmas time because of the shutdown of everyone's getting pissed from the 10th of December.
That's it.
If they try and waive that, push back.
Definitely. You want to have that up your sleeve just in case.
For sure.
Yeah, if you need a few more days. But if it's a good price that you've offered, the seller wants to sell it to you, you know, usually you can get a 1 or 2 day extension from the seller.
Cool. These feel like all really negative questions, but I think people only want to hear from a lawyer when it goes bad. When it goes good, it's just kind of smooth sailing. We get this question quite a bit, and we've actually done some videos on it in the past, but I want someone who knows what they're talking about's take on it. What's a sunset clause? Who does it benefit? And when should you use one?
So the sunset clause, it's tossed around in a few different contexts. So do you want to give me your context?
So we're making an offer. Potentially it's subject to sale. And in a market that doesn't have a lot of liquidity in it now and that its stock's tight, people want to know where they're going before they're selling. There's often, if we're putting a subject to sale clause on there, we'll also put a sunset clause on there to make it more attractive to the seller to accept it. Now you get to tell me what you think that clause is.
So the seller, the seller wants to be able to get a better offer, for example.
Yep.
Yeah. So not great for a buyer because usually what it means is the seller will say, okay, I'm going to continue to market this property for sale. If I can get a better offer from somebody else and it's up at my discretion, usually that's a higher purchase price.
Or less conditions, like no subject to sale.
Exactly, or less conditions. Then I can give you notice of that fact. And then you as the buyer, you might not have your building and pest sorted. You might not have your finance all tied up, but the seller will want you to go unconditional within, say, 3 business days or a period of time. If you do that, the property's yours, but that means you might not have finance. So you run the risk of, okay, I've gone unconditional, I've committed to buying this property, but now my finance is declined. I'm stuck. I'm now going to be in default of this contract. So it's risky for a buyer to go unconditional when they don't have all their ducks in a row. But it is good for a seller, of course, because they could get better purchase price.
I think it almost benefits both parties if you are confident and organised. It gives you the opportunity to look at buying something without having sold your place, but it's an out for the seller if they go, you know what, I'll take the risk on you selling your place in the next however many days or weeks, but if somebody else comes along and offers me less conditions, better money, whatever it is, I want to reserve the right to think about it, and I'll give you plenty of notice. We like them, but we like them where they can't be exercised for maybe 3 weeks after the contract date to give our clients the time to sort their shit out.
Yeah, and one of the options, if you need to sell your property to buy something else, maybe you can have a chat to your broker about bridging finance or something like that, so that you can go unconditional on that.
To make it work.
Exactly.
Yeah. We always think bridging finance is the last resort because it's so bloody expensive.
It is, but...
Yeah. You do what you got to do for the dream home sometimes.
That's it.
Okay. I got a question for you about mistakes. So from a legal perspective, you get a lot of contracts, probably signed and dated contracts. The first time you ever spoken to someone, what is the biggest or most common mistake that you see a lot of buyers make?
The purchasing entity. So the buyer hasn't put their full legal name. They haven't included middle names, or, the husband's purchasing, their wife was to be on the contract, but they haven't been included. So not all parties are a party to the contract. Sometimes the property description or the address is wrong, which is an issue when you need to go get finance and give the contract to the bank. Sometimes the special conditions are just worded really poorly and they just make no sense. So
don't write your own special conditions, ladies and gentlemen. Yeah. Matt says that to me all the time as well. But at least we get them checked.
Definitely get it checked.
Okay, so names, contract details, making sure that the legal address is the same as whatever the agent has put on the contract.
Correct.
Anything else that is easily avoidable?
I'm seeing a lot of contracts these days with not very many conditions, to be fair. But, for example, if you have finance, you need to make sure that every single particular of that finance section of the contract is completed. So let's say you've got a finance amount and a finance date. So it's 14 days from the contract date. But, hold on, finance amount.
Sufficient
or you
to
don't,
complete.
or let's say you don't have, let's say you don't put the amount in, but you've got 14-day finance. If you don't put an amount in, whether it's the loan amount that you need or sufficient to complete, that finance clause is not valid.
Okay.
It doesn't apply at all. So you have to have everything completed in the reference
Otherwise
schedule.
it's taken as null and waived.
There's no finance.
Okay.
Yeah.
So another question we have, we often get like a screenshot sent to us and it says in finance, sufficient to complete. And the first home buyer who's watched however many of our videos, listened to this show is like, what does this mean? Or what does buyer's choice mean in the financier? Right?
Yeah.
Do you want to just run us through
Yeah.
why that's okay?
Yeah. So sufficient to complete means that it's a loan for all of the money that you need to complete this contract. So that could include your transfer duty costs, for example, in addition to whatever the purchase price is. So it's not a bad thing to do. as opposed to just putting a set figure.
Of whatever you think your loan will be.
Exactly, because you might need more.
Yeah. And buyer's choice, they just throw that in there in case somebody's got a pre-approval with ANZ, but a better deal with NAB comes along.
Yeah, so it's not a bad idea though if you specify I need approval with ANZ, and then let's say, for example, you don't get approval with ANZ, then you can terminate under that finance clause, even if you could have got approval with ING.
Yeah, that's interesting.
So because the finance condition says, well, I didn't get approval with this particular lender, and that was my requirement.
Cheeky question for you. Let's say I've got a pre-approval with ING. Can I put ANZ as my finance clause and then still get my approval with ING, be like, well, guys, as long as I apply with ANZ?
You have to apply with ANZ.
Okay.
Yeah, you have to make an application.
Okay.
Yeah, so as long as you do make an application and then you get declined, but you don't really want to do that because it's going to affect your credit.
rating, which might then cook your ING one.
Exactly.
Yeah. Okay.
Yeah.
Very good. All right, last question for you, Nat. This has been really good. Thank you. What is your number one piece of advice for anyone who's hoping to buy a house this weekend?
This weekend. Talk to me today.
Get a contract
Get
review.
a contract review done before you sign. That is my piece of advice. If you talk to your mortgage broker, talk to your buyer's agent, talk to your lawyer, talk to your key people before you put an offer down so you know, yes, I can buy this property. Ideally, have some conditions in there if you can. If you're not going to get it checked by a solicitor or anyone, maybe you want a due diligence condition or a solicitor review condition of 7 business days, just so I can get my solicitor to review it, or have a cooling off period, and then we can check it during that cooling off period and do some searches on the property during that time.
Well said. Natalie Pearson, JHK Legal, thank you very much.
Thank you. Thanks for having me.